Weekly looks at some of the issues in the Court of Appeal judgment which freed Major Hamza Al-Mustapha and Alhaji Lateef Shofolahan. Both men had been handed the death sentence for the murder of Alhaja Kudirat Abiola. First, Mr. Femi Falana shares his perspective on the lessons from the judgment, and one of EFCC's foremost prosecutor, Mr. Oblah, speaks about the challenges of prosecution in Nigeria and other issues. I'm Shola Shele. It's a very informative episode. Let's begin right away with a recap of some of the top legal stories in the news. We begin with news that vacation started last week in some courts across the country. The Court of Appeal and the Supreme Court will, however, commence their vacation on Monday, the 22nd of July. During vacation, there will still be skeletal services, as a few judges designated as vacation judges will sit to attend to urgent matters. The courts are expected to resume from the vacation in September, when a new legal year will commence. A few judges still sat last week, though, to tidy up some cases before proceeding on vacation. One of them was Justice Lateef, who is presiding over the trial of former bank PHB boss Mr. Francis Atuche. The Economic and Financial Crimes Commission, EFCC, had charged Mr. Atuche, his wife Elizabeth, and the former chief financial officer of the bank, Mr. Ogo Anyanwu, with a 27-count charge of stealing the sum of 27.5 billion naira belonging to the bank. Mr. Atuche, however, opened his defense with the testimony of a former presidential candidate and professor of economics, Professor Patu Tony. The professor, who testified in his capacity as a member of the board of directors of Bank PHB at the time Mr. Atuche was chief executive officer of the bank, has said that he is personally convinced that Mr. Atuche is being prosecuted owing to the desperation of the CBN governor, Mr. Lamido Sanusi, to take over the bank. Another case of interest last week was that involving 32-year-old Quadri Kasali, a commercial bus driver. After spending over a year in detention, the Court of Appeal has granted bail to the driver, charged with the attempted murder of a Lagos High Court judge, Justice Ebenezer Adebajo. Quadri Kasali was first arraigned at the Tinubu Magistrate Court, Lagos, on the 9th of March 2012. From there, his case was transferred to the Lagos High Court. Both courts denied him bail, despite pleading not guilty to the offense. The Court of Appeal granted him bail in the sum of 100,000 naira and 2 sureties in like sum. He will, however, be back in court after the vacation to seek the quashing of the charges against him. In other legal news, the Legal Practitioners Privileges Committee, LPPC, last week Friday, confirmed the appointment of the EFCC's private prosecutor, Mr. Oblah. These days, lawyers Funke Aboyade and 17 other legal practitioners are senior advocates of Nigeria for the year 2013. The secretary of the LPPC, Mr. Sunday Olaundarsi, who made the announcement, named Professor Lawrence Asegboa of the University of Benin as the only member of the academia found worthy to wear the silk this year. The swearing-in ceremony for the new silks will be done in the new legal year. And we round off with news that the Lagos State Judiciary has commenced the first phase of its plan to reinvent its probate department. The probate department is that department saddled with the task of issuing a probate of a will or a letter of administration for the beneficiaries of a person who dies with or without a will. For a long time now, the probate department of the Lagos State Judiciary has grappled with a combination of challenges, including poor administrative practices and lack of information technology capacity. It was to address these challenges that the Chief Judge of Lagos State, Honorable Justice Ayo Phillips, set up a probate reform committee headed by the probate judge of the Ikeja Court, Justice Olubumi Oyewole. The committee is flagging off this training session of its staff as the first in a series of activities aimed at repositioning the probate department. The Chief Judge of Lagos, Justice Ayo Phillips, who declared the training open, shares a vision for the department.
It is my vision that the Lagos State Judiciary should move from the archaic way it did things in the past to be more IT compliant and move with the future. If we are not IT compliant, we cannot progress in the present day world.
The chairman and members of the probate committee believe that the work they have done and the innovations ahead will change the face of the probate department of the Lagos State Judiciary.
This entire training starts with changing the mindset, having a total paradigm shift in the approach to what probate is all about, to what judicial activity should be.
It's a very critical revenue generating department. When a deceased died, either intestate or testate, that is with a will, the state is entitled to 10% of the value of whatever estate that is left behind.
Indeed, the probate department is the main revenue-generating department of the Lagos State Judiciary. Between 2007 till date, the department has generated billions of naira for the Lagos State government. And with this reform intervention, the Chief Judge of Lagos is set to ensure that the problems of congestion, delay and poor service delivery are cut down.
So, okay.
You see, life has just got easier. You stay connected to Channels TV, where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
ChannelsTV.com. The news at your fingertips.
Welcome back. Reactions are still trailing the July 12 judgment of the Court of Appeal, which quashed the death sentence passed on Major Hamza Al-Mustapha, the former Chief Security Officer to late General Sani Abacha, and Alhaji Lateef Shofolahan, the former aide of the late Kudirat Abiola. Here is Senior Advocate of Nigeria, Mr. Femi Falana, with an interesting perspective on the judgment.
I had followed the case from the start, and upon a deeper reflection, I came to the conclusion that the accused person successfully exploited the defective Nigerian criminal justice system to escape justice. Let nobody say, therefore, that justice has been done. Because in a criminal case, it's been said, I think by the Honorable Justice Shukudifo Pucha, that justice is a three-way traffic in a criminal case. Justice to the accused, justice to the victim, and justice to the society. I think justice has only been done to the accused. But like the Court of Appeal rightly said, I agree that the investigation was shoddy. But the system has to be blamed for two reasons. A system that allowed accused persons to drag their trial deliberately for 12 to 13 years has to be re-examined. For instance, in a period of about 5 years at a stage, the court was subjected to 42 adjournments at the instance of the accused persons. Not only that, about 5 judges, the case moved from one judge to the other. There was a time a judge was falsely accused of having taken a bribe of $10 million. The case had to be suspended completely for the National Judicial Council to set up a panel that came down to Lagos, visited the accused persons in Kirikiri. to substantiate the allegation. Of course, it was found to be totally false. Again, our system, nobody was punished. And so the allegations of bias continued until the case had to travel around 5 courts. The system, the State Security Service, originally had a witness protection scheme for the witnesses who were going to give evidence. At a stage, that was cancelled. And the witnesses who had given evidence voluntarily, who at that time were being protected and taken care of by the system, were left alone. And what happened? Of course, they were contacted, and that was when they began to change their story. So whichever way you look at it, the system has to be blamed. It happened in the case of Chief Balagi. The man who had identified the killers and who had made a statement to that effect went to court and recanted. In fact, it was that singular incident that led to the untimely death of the Honorable Justice Atinuke. She couldn't cope. In this case, apart from the evidence in court, I was at the Oputa panel the day Sergeant Rogers gave his evidence. He cried. And the chairman of the panel, Justice Oputa, had to ask him, why are you doing this? He said, my lord, it takes more than the spirit of an ordinary human being to admit what I'm admitting. None of those indicted by him, particularly Major Al-Mustapha, could cross-examine him. Neither could his lawyer raise any question because the evidence was so believable. And that was what happened in court when the case first started. The killing, the gruesome murder of Mrs. Kudirat Abiola was described in graphic details by Sergeant Al-Mustapha. I collected 2 Uzi guns from Major Al-Mustapha and how they came to Lagos, how they procure a vehicle, and carry out the operation. And now, Lateef, Shofolahan, acted as a mole in the house.
Now, for more on Mr. Falana's reaction, do log into YouTube/channels web to watch the full interview. From that intervention, we move on to our interview for the week. My guest, Mr. Godwin Oblah, is one of the most prominent legal practitioners for the Economic and Financial Crimes Commission. A few hours before the Legal Practitioners Privileges Committee confirmed his elevation to the rank of Senior Advocate of Nigeria, I spoke with him about some of the challenges hindering swift prosecution in the country today. Let me begin by asking if you've read the recent Court of Appeal judgment on Al-Mustapha, the one that quashed his death sentence.
No, I just read excerpts of the... Okay,
you followed it in the media.
Oh, yes.
But, for some people, it's brought again to the fore the role of prosecutors in the country. The Court of Appeal said so many things: shoddy preparations, shoddy investigations, the prosecutors didn't do a thorough job, contradictory witness statements and all of that. But you are one of the most prominent prosecutors in the country, and how would you assess the quality, the training and the outputs of prosecutors in the country today?
Let me first and foremost say that I haven't read the full judgment, but I also know that the Court of Appeal is manned by very seasoned judges, and whatever they say in a particular appeal must be taken very seriously. Having said that, it's important to stress that there are no professionally trained prosecutors in the American style in the country. We don't have that kind of system here. Every lawyer has the potential of becoming a prosecutor in Nigeria. I was a defense attorney for a very long time before I switched sides and actually started prosecuting. It takes a lot of training and it takes a lot of years to actually perfect the art. But no matter how good you are as a prosecutor, you can only succeed with the quality of materials or evidence that are also presented to you. The Al-Mustapha case is a case of national importance. For political reasons, for sentimental reasons, and for family reasons. But having said that, decisions of courts are not based on emotional reasons. They are based on hard facts and the application of the law. And I think that is what happened in this particular instance. Prosecutors may have their blame in it, but substantially the background from what I see is that the materials even presented to the prosecutors are not the best materials, having regard to the fact that this is a criminal trial where the standard of proof is beyond reasonable doubt. It's not a civil trial. And I'm sure that was why the Court of Appeal came to the conclusion that they came to.
So what are you saying as regards the quality of prosecution, the training and the outputs that we have in the country today?
I think there should be less emphasis on the quality of the prosecutors. There should be more emphasis on the materials that also get to the prosecutors. Okay. Let me give you a small example. When the former PDP governorship candidate for Lagos State died, I can't recollect his name. Funsho Williams died. The first thing that happened was that the scene of crime was not secured. So when Nigeria, in an effort to show that they were actually taking that particular incident very seriously, now decided to ask for foreign help, it was useless. Because when Scotland Yard came and went to the scene of crime, there were over 1,000 fingerprints. So it was completely useless. And it is what keeps recurring here. Nigeria doesn't have a proper forensic laboratory. Even if it has, it doesn't have investigators that can properly manage and make any good use of actually the proceeds of the investigations that they do. So you see an investigation involving murder, and there's no forensic background to it. There are no fingerprints. Nothing is tied to an accused person vis-a-vis the evidence and things like that. So when you give materials to the prosecutor, most times they're either guesswork, or they're based on conjecture, or they're based on circumstantial evidence. And in all these cases, they have to be such that it will be absolutely safe to convict an accused person based on such evidence. So yes, prosecutors need training, but not only prosecutors, even the judges need training. Even the defense counsels also need training. And the existing laws that we also have, are they also helpful in the circumstance?
So if you were to give suggestions for having the kind of prosecution that we should have, the kind of prosecutors that we should have, what would be the suggestions that you would give for reforms? I
think we need to start from the background. What is the curriculum of the law school, which is the training ground for Nigerian lawyers? Are there aspects of the curriculum that address issues of prosecution? And after that, we have what we call continuing legal education. What programs have we also put in place to continually train lawyers, prosecutors, and defense attorneys alike to improve their skills as lawyers and offer better services to the society that they serve? Unless we do that, because most of the curriculums we have, if you check it, for years, these things are not reviewed. for years. These curriculums are not reviewed. I can't remember the last time the law school curriculum was reviewed, but I know that there's a new committee that has actually been set up recently to review the curriculum of the law school. But these things need to be reviewed regularly because science is changing, technology is changing, human conduct is changing, and the laws must reflect all these developments.
There's this allegation against agencies like the EFCC that they spend money to engage private legal practitioners like you, rather than train their in-house lawyers. It's like duplicating resources.
Well, let me tell you, they have so many in-house lawyers at the EFCC, they have at the ICPC, and they're very busy. But the quality of representation that also comes from outside counsel cannot be quantified. Even the federal government, with a huge Ministry of Justice, still retains outside counsel. Even in England.
Okay, so it's not limited to Nigeria?
No, it is not. And in any case, don't forget that the criminals or the accused persons have the benefit of the best counsel anywhere in the world.
Yes, they get all the best senior advocates.
Yeah. You know that in some of the cases that I do as an EFCC prosecutor, one accused person will come with about 7 senior advocates of Nigeria and about 23 other lawyers. Let us be honest. The typical counsel working with government is a civil servant. Don't forget that. And that there's a psychology about this fight. That when you come at times, maybe 1 or 2, and you are arrayed again, it's like a David and the Goliath fight. Before you start, there's a psychology that, look, this is a lost battle already. It's not in all cases.
When you look at the team of the other side, it's enough to even depress. You know?
You know, so at times you need to also show the public that you are serious about this fight. When people complain that these outside counsels are actually paid a lot of money,
yes.
What the law factor is, once those outside counsels are not there and the in-house counsels lose the case, the whole public will now begin to scream, but you saw that they brought 7 senior advocates. Why didn't you go and also get a senior advocate to counter them? It's typically Nigerian. But having also said that, people are not aware that we're making a lot of sacrifice. It's not all the time that we get paid. A lot of people are not aware of it. But I'm sure, because it's not necessary for us to also say it, but I'm sure if they also check the records at EFCC and other anti-corruption agencies, and thankfully, you know, they have the right now because under the Freedom of Information Act, you can ask for the information. How much have you paid these lawyers? And you get those informations.
I know that there is a case like that where they've asked for information. I'm not aware that it has been provided.
Well, I'll be happy for those information to be provided. Because if they are provided, the public may be surprised.
Okay, one final issue. This controversy over fiat issued to private legal practitioners to prosecute by the AGF, you know, by the Attorney General of the Federation. It's becoming a recurring issue now. The federal government, the fiat of the Attorney General to prosecute. What's the procedure for the issuance of the fiat? What's the presentation?
That issue is not necessary. It's a mischievous distraction. That matter has been settled by various courts in this country. And I'm surprised that any counsel what is sought will be raising that matter. The matter was raised in the prosecution of Akimbola before Justice Abiola.
It was also raised in the prosecution of Femi Falana.
It was dismissed. Went on appeal. I argued that appeal. It was dismissed. And the Court of Appeal made it clear that EFCC does not even require anybody's fiat to prosecute all those cases. It doesn't require anybody's fiat to prosecute all those cases. Because the Act, the 2004 Act 7 of the EFCC, made it a coordinating agency for the enforcement of specified laws that were listed in the Act. So, why are people continually raising issues that have been settled in law? it's part of the issues that we have actually discussed. People say lawyers, when they get paid, they raise all sorts of objections just to delay the trial.
Because we saw in one instance that the court adjourned because of this issue of theft. I'm talking about the case of Femi Falana, and the court adjourned over this issue of theft. So does it then mean that perhaps judges should also be more proactive, or I don't know?
Well, some judges are extremely proactive, but everybody cannot be very smart. That's the honest truth. I see a lot of judges that sit immediately and dispose of all those kind of matters, and they tell you as a counsel straight to your face that you should be serious, that this matter has been settled, shouldn't waste his time. And some of these judges will go ahead and say, okay, go ahead. You have a right to fair hearing, so you are entitled to every application that you have filed to be heard because you paid for it. So you move the application, and right there and then the judge issues a bench ruling and dismisses it. And that's the proper thing to do.
That's our show for today. Do remember that you can catch any part of the program you missed by logging on to our YouTube page. Also follow me on Twitter and send me your comments and questions. I'm Shalashi Eli. Thank you for watching.